Separation. The word sounds simple, but in family law, it has a specific legal meaning, and getting it wrong can affect your divorce application, your property rights, and the time limits that apply to your situation. So when does separation legally start? Under the Family Law Act 1975, separation begins when at least one party communicates, by word or conduct, that the relationship has ended. It does not require both parties to agree. If one person clearly communicates that it's over, separation can begin from that date, even if the other party doesn't accept it. And importantly, there is no formal paperwork. Separation is a matter of fact, not a legal process. A question we hear a lot: does separation require moving out? The answer is no. Couples can be legally separated while still living under the same roof. What matters is whether you're still conducting yourselves as a couple, sharing a bedroom, presenting publicly as partners, socializing together, sharing finances. If you're genuinely living separate lives, you can be legally separated regardless of the same address. Now, why does the date of separation actually matter? 4 reasons. First, the 12-month clock for divorce starts running from separation. Second, de facto couples only have 2 years from separation to commence property proceedings. Miss that deadline and you may lose your rights entirely. Third, assets acquired after separation may be treated differently in property settlement. And fourth, spousal maintenance obligations don't automatically end at separation. What if you're not sure of the exact date? That's very common. Not all relationships end with a clear conversation. Courts will look at surrounding evidence, text messages, emails, sleeping arrangements, separate finances, to establish when separation most likely occurred, and if you reconciled and then separated again. Generally, the clock restarts. But short reconciliation attempts under 3 months that ultimately fail may not reset the full period. You may be able to add the separate period